Hello everyone, once again welcome you to our page Know the Law. My name is Joel Ivan. But before I proceed, I would like to kindly ask us to subscribe to our channel because it's so heartbreaking how we can have more than 90 viewers of a specific or a given recording, but we only have 5 likes, 40 subscribers. It's so heartbreaking. Kindly support us as we support your academic progress, right? It's a small request. Anyways, today I want us to look at statutory interpretation or construction. So these two words are used interchangeably, but they mean the same thing: statutory interpretation. So you're going to be guided by the following questions. One is in quotations, and it goes, Judges are only supposed to construe statutes by exclusively looking at the wording therein. Any external considerations by courts aimed at identifying the so-called cure in the statute is self-defeating of the purpose of the lawmakers, which is to at all times construct unblemished laws. Therefore, such alternative approach must be avoided. With relevant authorities, discuss the veracity of this statement. Then the second question goes, it's also in quotation. The rules of statutory interpretation are rather crude labels for describing a complex mechanism. This is to say, making sense of what somebody else has written. The labels are still in common use, but they are dangerous. For a start, they use the word rule, and this gives the impression that if you follow a particular pattern, you are going wrong. The question is, explain the rules of statutory interpretation, discussing the extent to which you agree with the above expressions made in the above quotation. Anyways, statutory interpretation. What is statutory interpretation? Simply put, statutory interpretation or construction is the process where our courts interpret and apply legislation, right? Sometimes the words of a statute may have a plain meaning. However, in given circumstances, certain provisions have ambiguities in them, right? And the same ambiguities have to be resolved by judges. So this is where judges derive their authority to interpret the law. All right, let's first go into details of where these judges get their power or powers to interpret the law. I believe we all did constitutional law and administrative authorities, where we looked at the doctrine of separation of powers. So I would re-echo it. I'm not going to go into details, but I'm going to talk about something small about the about the doctrine of separation of powers. So Montesquieu, in his doctrine of separation of powers, tells us that for a government to be considered a constitutional government, it should have at least 3 arms of government, namely the legislature, the executive, and the judiciary, right? It should have at least 3 arms organs of government. That's one. Then 2, he tells us that these 3 arms of government should at least be led by 3 different persons or independent individuals. Yes, for instance, the executive should be led by a different person. So should be the case with the judiciary and the legislature, right? Then lastly, he tells us that the 3 arms of government should have different functions, right? Should execute their functions independently. So this takes us to the functions of each arm of government. The legislative arm of government has authority to make laws, amend, and repeal rules of the law, right? So we can read, we can understand this in conjunction with Article 79, Clause 1 of our Constitution, the 1995 Constitution as amended. It mandates Parliament to make laws of good governance for Uganda, right? Yes, after making the law, the executive comes in. The executive has power to execute and enforce the rules of law made by Parliament. It's not Parliament that enforces or executes the law. Parliament has a function of making the law. The executive comes in to enforce the law, to enforce and execute the law. Then, what is the rule? What are the functions of the judiciary? The judiciary has authority that if there is any dispute, they have the authority to determine what the law is and how it should be applied in the dispute. So this is the function of the judiciary, to interpret and apply the law. This is where it derives its function. Its mandate of applying and interpreting the law, right? So this is where it gains its authority of interpreting statutes made by Parliament and executed or enforced by the executive arm of government. So that's the doctrine of separation of powers. Having understood where the judiciary derives its authority of interpreting statutes from, let's now look at the rules governing statutory interpretation. We mainly have 3 rules of statutory interpretation, though most of you split one of them and make them 4, but we have 3. So we have the literal rule, the golden rule, and the mischief or purposive rule. So let's look at the literal rule. The literal rule means that words of the statute should always be given their original natural meaning upon interpretation. So if you're reading a statute, you should read the provisions the way they are. That's if at all they are clear and unambiguous or plain, right? So actually, it's the general rule under statutory interpretation that where the words of a statute are plain, clear, or unambiguous, courts shall, upon statutory interpretation, give the literal meaning of the provision. So therefore, the literal rule, takes first priority under statutory interpretation. For instance, if you're reading section 26 of the Sale of Goods Act, it talks about ascertaining intention as to the time when the property in the goods passes from one person to another. So just read the way it is, right? Just read the provision the way it is. That's the literal rule. Actually, it was reaffirmed in the case of Nyamunchoncho and others versus Attorney General, where it was held that words of a statute must be interpreted according to their literal meaning and sentences according to their grammatical meaning. If the words of the statute are clear and unambiguous and complete on the face of it, they are conclusive evidence of the legislative intention. This is what is today referred to as the literal rule of statutory interpretation and was defined in the case of Weeks versus DPP. That's 1947 appeal cases at page 362. So that's the literal rule of statutory interpretation. Let's look at the importances or the rationale behind the literal rule, the importances or justifications of using the literal rule upon statutory construction. One, it respects parliamentary supremacy and the right of Parliament to make laws as it wishes, because we understand that Article 79 at clause 1 of the Constitution gives Parliament mandate to make laws in Uganda, right? So the literal, if you're reading if you're reading the act made by Parliament, read it the way it is, and by so doing, you're respecting its mandate given to them by the Constitution, right? Then secondly, the literal rule also guarantees that the doctrine of separation of powers is upheld. It is tried law that a word cannot be inserted in a statute while interpreting it, where the legislature did not use such word, and in case that is done, then it tends to violate the principles of separation of powers. So we've looked at separation of powers, and here we are saying that the literal rule respects the doctrine of separation of powers, right? Because it's Parliament that makes laws. So judges, while executing their mandate, should not make laws, right? If a judge is mandated to interpret the law, why do you insert a word in the statute which the legislature or the draftsman did not intend to mean? By so doing, you're violating the principles of separation of powers and you're making laws. Are we together? Let's look at given circumstances where the literal rule was used under statutory interpretation. Let's look at the case of Fisher versus Bell. This is 1961, volume 1, Queen's Bench at page 394. This case is so common under contracts 1 when you're looking at the difference between an offer and an invitation to treat, right? So under the Offensive Weapons Act of 1959, it was an offense to offer certain offensive weapons for sale. Bristol shopkeeper James Bell displayed a knife, a flick knife in his shop window. When brought to trial, it was concluded that Bell could not be convicted given the literal meaning of the statute. The law of contract stated that having an item in the window did not show any intention of selling, but rather an invitation to treat. So given the meaning of given the literal meaning of the statute, Bell could not be convicted under the above law. Are we together? So this meant that under contracts, we understand that mere display of a given something which is prohibited from being sold in your country, and you display it in your window or at your shop, it does not show intention of having it sold, but rather it's an invitation to treat. What is an invitation to treat? You're trying to call you're trying to call customers so that they come and buy from you, right? But you do not intend to have that same thing sold to them. Are we together? Perhaps in due course of them coming to your shop, they may get something else other than what brought them in your shop. So that's the literal rule. Then second, let's also look at the case of R versus Harris. That's 1936, where the defendant beat the nose of the victim. The statute stated that it was an offense to stab or wound a person, and under the literal rule, biting is not stabbing, right? And cutting or wounding. So this implies that in order to cut, you need an instrument like a knife to cut. Therefore, the defendant only did what? Only used his teeth to bite off the nose. The nose of the victim. Therefore, teeth are not instruments, right? So he could not be convicted as well. So this is the literal rule of statutory interpretation. Where words are clear and unambiguous, you use the literal rule of statutory interpretation. You read them the way they are, right? Anyways, let's look at the golden rule of statutory interpretation. So, the golden rule of statutory interpretation, simply put, it only comes in where the literal rule gives an absurd result which Parliament could not have intended. Therefore, it gives a judge powers to substitute a reasonable meaning in light of the statute as a whole. So they're telling us under the literal rule that if the words of the statute are clear, then read them the way they are, give them their natural meaning. But in circumstances where the provision has grammatical errors, then we employ the golden rule in order to maybe substitute with a reasonable meaning in light of the the whole statute. And the rationale behind this rule is that the legislature could not have possibly have intended what its words signify, and the modifications made are mere corrections of the carelessness of the draftsman, right? Because while enacting these laws, you never know, these draftsmen may make errors, because errors are common, right? And these errors could be typographical or grammatical, right? Therefore, the the golden rule comes in to have these loopholes covered. Are we together? So let's look at the definition of the definition of the golden rule given under the case of Gray versus Pearson, 1875. They are telling us that the grammatical and ordinary sense of the words is to be adhered to, unless that would lead to some ambiguity or some repugnancy or inconsistency with the rest of the instrument, in which case the grammatical or ordinary sense of the words may be modified so as to avoid the ambiguity and inconsistency, but no further. So just like I said, it only comes in to modify the literal rule. Are we together? Where the literal rule fails, we employ the golden rule. So let's look at a circumstance where the golden rule was used. We have a common case of R versus Allen. Yes, this was in 1872. In this case, the defendant was charged with bigamy or bigamy contrary to Section 57 of the Offences Against the Persons Act 1861, which under the statute stated that whosoever being married shall marry any other person during the lifetime of the former husband or wife is guilty of an offense. So if you read this statement, of course, it does not, it gives you an absurd result if at all you employ the literal rule of statutory interpretation. But because if at all you use the literal rule, bigamy would not be possible because civil courts do not recognize second marriages. So the golden rule was applied to determine that the word marry should be seen as to go through a ceremony, and the conviction was upheld. Are we together? So we've seen that if at all the literal rule is giving you an absurd result or outcome, then kindly employ the golden rule to give an alternative meaning of what the legislature would have intended. Are we together? Because mistakes are common and human. So let's look at the advantages. The main advantage of the golden rule is that drafting errors in statutes can be corrected immediately. This is seen in the case of R versus Allen, where the loopholes were closed. The decision was in line with Parliament's intentions and it gave a more just outcome. Yes, we've talked about errors being common, so it covers up these errors. And yes, for justice to prevail, yes, why not use the golden rule? Then the main disadvantage we have is that the golden rule gives judges powers to make laws. Are we together? And of which it contradicts the doctrine of separation of powers, because under we saw that we have three arms of government whose functions are so different, right? The legislature is mandated to make laws, and the judiciary only comes in to have that law interpreted. So under the golden rule, the judiciary is seen inserting alternative words in the provision of the law. So you never know, right? You never know. The judge may end up doing what? The judge may end up changing the whole provision of the law, right? Because we see in the case of we see in the case of Hill versus East and the West Indian Dock Company, it was stretched that what seems absurd to one man does not seem absurd to another, right? One judge may see this provision as absurd if at all they use the literal rule, but to another person it would not be absurd at all. Therefore, it does what? It violates the doctrine of separation of powers. So, in circumstances where courts fail to interpret a given provision of the law using using the literal and golden rules of interpretation, then it is allowed in strictly limited circumstances to use the mischief or purposive rule. Then what is the mischief or purposive rule? The mischief or purposive rule is applied in situations where courts want to know the aim of passing a given statute. Are we together? So in the case of Nyamuchoncho, Justice Sekana further explains that oftentimes courts apply the mischief or purposive rule in statute interpretation where the words of the statute are not clear. Are we together? So where the words are not clear enough and courts have failed to get the meaning or the intention of the legislature, right, using the literal and mischief and the golden rule, they'll resort to the purposive or mischief rule, so that to determine what mischief was in place, right, so that Parliament enacted this law. So it should be noted that before enacting a given law, Parliament seeks to sweep out a given mischief. We have an instance of the Homosexuality Act of 2023, right? Parliament wanted to curb homosexuality in Uganda. That's why it did what? It passed the Homosexuality Act of 2023. So the mischief was homosexuality. So if we are looking at the mischief or the mischief or passive rule, we are trying to find the reasons why Parliament enacted that law, right? So the mischief or passive rule derived its genesis from the from the Haydon case. Yeah, was it the Haydon? Yeah, Haydon's case of 1584, and that case gives us 4 principles that we should look out for when we are applying the mischief rule. 1, what was the common law before the making of the act, right? Then 2, what was the mischief and defect for which the common law did not provide? 3, what remedy Parliament what remedy did Parliament want to resolve, right? Then lastly, the true reason of the remedy, and then the office of the judges is to make such construction as shall suppress the mischief and advance the remedy. So the rule is intended to rectify the mischief in the statute and interpret the statute justly. This mischief rule mischief rule uses common law to determine how the statute is interpreted. Are we together? So in order, actually, those of you doing jurisprudence 1, you should those of you doing jurisprudence 1, when you're looking at anthropology, they tell us that in order to understand where you're going, it's very important to understand where you came from. That's the anthropology school of law. It also applies to the mischief or passive rule of statutory interpretation, right? What was the mischief before Parliament passed the law? What was the aim of Parliament passing this law? Let's look at the case of Smith versus Hughes, 1960. The defendants were charged under the Street Offences Act of 1959 with soliciting in a public place. The prostitutes were soliciting from windows, technically not a public place. The mischief rule was applied to interpret that the prostitutes were doing what the statute was trying to abolish, so they were convicted. I think let me repeat this case. Under this case, the defendants were charged under the Street Offences Act of 1959 with soliciting in a public place. Literally, the prostitutes were soliciting from windows, not in a public place. Are we together? So court used the mischief rule and to interpret that the prostitutes were actually doing what the statute was trying to abolish. So the mischief was soliciting, right? The mischief was soliciting. So regardless of the fact that these people were not soliciting in a public place but in the window, so using the mischief rule, yes, they would be convicted. Reason being, they were doing what the act aimed at abolishing. Are we together? So let's look at the disadvantages and some of the advantages of the mischief rule. The main advantage of the mischief rule is that it closes loopholes in the law and allows the law to develop. However, the main disadvantage is that it creates a crime after the event has taken place, which can be seen in the case that we've just read, right? It allows judges to apply their opinions, and this prejudice the doctrine of separation of powers. So the advantage we've talked about, developing the development of the law, then it closes loopholes in the law. Are we together? Then the disadvantages, it's one main disadvantage, infringement on the doctrine of separation of powers. So lastly, let's look at the aids of statutory interpretation. The aids of statutory interpretation. So an aid or a tool is a device that helps or assists, and for purposes of construction or interpretation, the court has to take recourse to various aids of statutory interpretation, and we have 2 types of aids, right? We have internal and external. Let's look at internal briefly. Internal, you're looking at the act itself, right? The aids under the act, things under the act that are to help you explain the act or interpret the act. One of them, we have the title, right? Under the title, we have two types. We have the long title and short title. So the long title of a statute is an internal part of the statute and is admissible as an aid of construction. Statute is headed by a long title and it gives the description about the object of the statute. It begins with the words "an act to." So let's look at our act. With me, I have the Sale of Goods and Supply of Services Act 2017, right? So let's look at the the long title. The long title is here, right? An act to provide for the formation, effect, obligations, and performance of contracts for the sale of goods and supply of services, to provide for remedies of the parties under those contracts, to provide for consumer protection and for related matters. So that is the long title. So if you're interpreting a statute, you ought to look at this, right? So what is the short title? A short title is an of an act is the title. The short title of an act. It gives the reference of the of the act. It gives reference. It gives the reference of the act for its identification. For instance, if I want the Sale of Goods Act to distinguish it from other acts, it is the short title, the Sale of Goods and Supply of Services Act 2017. That is the short title. Are we together? Okay, let's look at the headings and title of a chapter. Headings are of two kinds. The one prefixed to a section and another prefixed to a group of or sets of sections. So the heading. So let's look at the heading. One of the headings we have, for instance, I have the Sale of Goods Act I told you, and one of the headings I have the it's part 2, formation of contract of sale and supply of services. So that is a heading prefixed to a group or set of sections. Are we together? Then we have one prefix to a section, which is sale and agreement to sell goods. Are we together? So this can also help you to understand or to interpret a statute. Then we have marginal notes. So gone were the days when our statutes had marginal notes. I think I have ever seen one, right? So marginal notes are so common in dictionaries and other books, though they can also help you in interpretation of statutes. So definition sections. Every act has the interpretation section, right? So you go to the interpretation section, you can find out what they meant. For instance, if I want to find out what they meant by the term ascertained goods, I will go to section 1, which is the interpretation, and I'll read ascertained goods. Ascertained goods meaning goods which have been identified subsequent to the formation of this contract. So that is the interpretation section or clauses. All right, so you could look at the provisions themselves. Yes, you could look at the provisions. You could look at the explanations themselves. You could look at the punctuation. However, punctuations are so minor elements in construction. Only when a statute is carefully punctuated and there is no doubt about its meaning, right? And weight can only be given to punctuation. It cannot, however, be regarded as a controlling factor for determining the meaning of a statute, the punctuation. So this is also so minor. Let's look at the external aids. The external aids we look at outside the act. We close our act and we look for anything outside the act that is going to help us understand a given provision in our act, right? In our act. So this is often used by judges who adopt the mischief, because the mischief, we want to find out what mischief the act intended, or the parliament intended to cure, right? So one of the external aids, we have dictionaries, right? Dictionaries. So in the case of in the case of R versus Peters, it was noted that it's a quotation, a good quotation that I got that I want to share with you guys. A judge noted that I'm quite aware that dictionaries are known to be taken as authoritative of meanings of words used in acts of parliament, but it is a well-known rule of courts of law that words should be taken to be used in their ordinary sense, and we are therefore sent for instruction to these books. So this gives us the authority to use dictionaries. Yes, actually in Ugandan context, you could even use the Black's Law Dictionary. Oftentimes courts use the Black's Law Dictionary while doing what? While interpreting given provisions of the law. Are we together? So let's look at let's look at at other external aids. For instance, we could look at earlier judicial decisions or the doctrine of stare decisis regarding the provision and the interpretation provided it is binding. In the case of London Transport Executive versus Batts, Lord Denning, in his dissenting judgment, was of a view that decisions of interpretation should only be regarded as authority for what they actually decide in subsequent cases involving similar facts. So in his opinion, it was up to each new court to decide whether the situation before it differed in a material respect from that in the previous case. So they're telling us that you can also look at earlier judicial judgments or decisions of courts to help you do what? To help you interpret the statute. Are we together? You could also look at parliamentary materials such as Hansards, right? Hansards. So, in the case of Eastman Photographic Materials Company Limited versus Comptroller General of Patents, it was noted that where Parliament is legislating in light of a public report, I can see no reason why a court of construction should deny itself any part of that light and insist on groping for a meaning in the darkness of or half-light. I conclude therefore that such a report should be available to the Court of Construction so that the latter can put itself in the shoes of the draftsman and place itself on the parliamentary benches. So these Hansards help you a lot, or reports and hazards help you a lot in statutory interpretation, because they'll give you maybe the aim why Parliament passed that law, right? How they voted, the discussions and debates. Are we together? So even parliamentary debates can help you, though indirectly, can help you to do what? To interpret these laws. Then international treaties and conventions, they can also help you. You read in depth other external aids for statutory interpretation, because I know I've left some of them, right? I've left out some of them, but time is against me. Anyways, thank you very much. That is statutory interpretation for us. So in reference to the question that I gave you, whether judges are allowed to make law, I gave you a question which said that judges are only supposed to construe statutes by exclusively looking at the wording therein. Yes, right? They should interpret laws by only looking at statutes. By exclusively looking at the wordings in the statutes. However, they are also allowed to look outside the statute if the literal rule does not give them what they want, or leads to an absurd result. Then they are allowed to look outside the statute, right? For ends of justice to meet.